Every co-op board deals with difficult shareholders, and sometimes those situations can disrupt life for the entire building. Relying solely on the courts can be slow, complicated, and costly, but there are steps boards can take early that can help and even prevent problems from escalating.
At the Folsom Group, our mission is to help boards make smart decisions every day. From end-to-end property management searches and construction project management to cost optimization, we help boards achieve sustainable savings, on-time projects, and long-term performance that speaks for itself.
I'm Emily Myers with Habitat Magazine, and my guest today is Emanuela Lupu, partner at Smith Buss & Jacobs. Emanuela, thanks so much for being here.
It's my pleasure. Happy to be here.
So when a shareholder's behaviour becomes a nuisance or objectionable, it can put real pressure on the building and the board. How should co-op boards be approaching this problem?
Making a record and maintaining a record and keeping really, really clean records of what's happening is your primary objective when you're at that point. Always feels like you're never going to forget what happened on this day or that day. But I assure you, a year or two later, when it's time to actually put it on paper or present it to a court, or oftentimes even 3 or 4 months later, it becomes a monumental task to be able to start compiling the information. So my advice to all of my boards and my managing agents is make a record and keep a very detailed record of everything that's going on. And that should include any communication to the shareholder, communication from or to neighbors, other residents in the building, staff members, different members of the management staff. And by record, I mean written record. I don't mean little notes. I don't mean an email that's going to go into an email box that we're going to have to locate later on. I mean actually keeping a track of what's going on a daily basis. The advice to neighbors, and I do engage and request that the boards engaged with people that are lodging the complaints, is always to maintain a log. It's very old school, very antiquated, but it works. It's actually admissible in court. Not only does it help to keep everything fresh in everyone's minds, but it lends a level of credibility to what's being said when it is ultimately in front of a judge, and it is admissible as an exception to hearsay. So a log is literally a piece of paper. Could be a little notebook, could be a little pad that you keep very close to you, where you jot down date, time, and description of what it is that you're seeing when you're seeing it. From the management's perspective, send letters to the shareholder when you get a complaint. Send letters when you find out something's gone on. If a staff member is the one lodging a complaint, which happens a lot, could be a porter, it could be a plumber, it could be the exterminator that came in for the day. Write it up in a letter, have them sign and notarize, and have it notarized. You don't know that staff member will be around 6 months or 8 months down the line or a year down the line. They may not be employed any longer with the organization. They may have left the country. It could be worse than that. Having that information on paper and maintaining that in clear records is imperative.
So you're pointing out, obviously, record keeping is important. But for a board, of course, it's often difficult to know when something starts, whether it's going to be an isolated incident or if it's going to continue. Is that where boards get tripped up and where the problem can develop in which they do not have those contemporaneous reports because they don't know what the situation is?
So my answer to that is that don't pick and choose. My biggest advice to all of my boards at all times, regardless of what the conversation is about, is policies and procedures. So, and that is the key to running a good corporation, regardless of whether it's a co-op, a condo, or just a regular corporation. At the end of the day, it's about having policies and procedures. If you establish a procedure where any complaint has to be recorded in a certain manner, any complaint has to be submitted in writing, and management is made aware, because usually this does filter through management most of the time, and often your staff, depending on whether you have a resident manager or a resident super, or if the board members are dealing with it on their own, set a policy and procedure. And this is maybe create a form that you can hand to people to say, great, could you please fill this out and give it back to us? Let's scan it and save it. And I used to say, put it in the file. Scan it and save it is the way of today, but put it in the file works just as well. At the end of the day, you don't know. You don't know. I've had situations where a gentleman had an arsenal of weapons in his apartment. It was a one-off, hopefully a one-off, but you still had to make a record of it. If you don't keep that record 4 or 5 years down the line, if God forbid that were to happen again, it's impossible to take action because you can't establish what happened in the past. So it is imperative to keep these records. And the only way to keep yourself from getting tripped up is to create a policy and a procedure for how to address anything that happens. I mean, I can give exaggerated examples or simple examples, but regardless of what it might be, put it on paper and throw it in the file.
Okay, you're sharing some examples of nuisance or objectionable conduct. What have you encountered, and what's the most prevalent concern for boards?
I've seen it all. The last, believe it or not, 6 or 7 months, it's become exacerbated, and it's odd. Post-COVID, it got a lot worse, and then it kind of slowed down a little bit. But now it just seems to be out of control, and a lot of the out of control is conduct. It's harassment of staff members. It's harassment of neighbors. You get the old pounding on the floor when you think the music is too loud, or yelling at a staff member because they're not doing something the way that they want it done. And it sounds simple, but if you multiply that times 100, it gets exaggerated. The other part that I'm seeing a lot of are extremely litigious individuals who, the words "a little knowledge is a dangerous thing." The internet imparts a little knowledge on everyone today. ChatGPT can throw together a really bad summons and complaint very easily, and good enough to walk into a courthouse and pay a filing fee to get filed. So I'm finding that a lot of the objectionable shareholders seem to be utilizing the court system to put pressure, I guess, on the boards, or fear on some part of it, in pursuing their conduct. That in and of itself is objectionable, bringing baseless lawsuits against the co-op, costing the co-op funds to defend lawsuits that have no legal merit or basis. I have a shareholder currently who's filed a federal discrimination complaint, 2 HP actions claiming that they need repairs, have been ordered to give access and then don't give access on the dates. I've had to send an associate there for the access dates so we can record what's going on, anticipating that access would not have been granted. We're building up to an objectionable conduct case. But the buildup is more important than the case itself. And when you talk about record keeping, yes, the past record keeping is imperative. But as you're building up to the case, making sure that you are 100% in the right at all times, and be really maintaining clear records of what's happening every step of the way is imperative, because these cases, especially in the objectionable conduct realm, are not won on whether the conduct was objectionable or not, because ultimately the courts defer to the opinions of the boards on that matter. That's what the Pullman case is really all about. That's where objectionable conduct stemmed from back in 2007 when the case came down, and it's been used a million times since then. It really is about doing the process correctly. And the only real trip up for boards when you get to the point where you want to bring this case and win it is being able to establish that you've acted in good faith, being able to establish that you've acted within the confines of the business judgment rule, and maintaining the records and following through. And what I had said earlier was always being 100% in the right is imperative to making sure you get over that hurdle.
Okay, so and you've pointed out, there are 2 routes for boards when dealing with this kind of conduct. There is the objectionable conduct, which would lead to termination, but there is a violation of the proprietary lease, which has a different outcome. It's simply that the shareholder needs to stop.
There are 2 roads, both of which lead to landlord-tenant court or Supreme, depending on what your choice is, what your decision is, let's say. Option number 1 is objectionable conduct, although really that should be option number 2 because it's for the more grave situations. Option number 1 would be a simple holdover proceeding. where you would serve a notice letting the shareholder know that they violated certain sections of the proprietary lease, be it an illegal alteration, noise, odors, subletting, whatever that might be, and demanding a cure. If the cure doesn't happen and the conduct is repeated at the expiration point of that notice, then the proprietary lease would be terminated and you'd start what's called a holdover proceeding. In those types of actions, the court will continue to give the shareholder opportunity to cure, whether you want them to have it or not at that point. At any given moment in either path, you, the board, can decide to give it a timeout and stop. You can always backtrack from whatever action you've taken. So I've had that question come from a lot of boards concerned that someone might completely change their ways and want to be able to give them secondary shots at correcting their conduct. That's always available to you. You're driving that bus at all times. The first method, however, in starting a holdover proceeding, the courts will continue to give the shareholder opportunities to cure. And problematic, I can give an example here that I think is very apropos. I had a shareholder who had extreme odors in the apartment. They may have been cat urine, they may have been other things, but they were so extreme that you could smell them throughout the hallway. Happened to be a first floor right by the entrance of the building, and everybody was blessed with the odors when they walked through the door. We got to the point of having to commence a regular nuisance holdover proceeding for the odors. And 6 months into the litigation, she cleaned up the apartment. The odors stopped. It's great news. Wonderful news. Except now the court said, well, she's corrected, case is over, and you're not getting your legal fees co-op.
Aha.
And that's problematic because under the terms of everyone's proprietary leases, the legal fees are supposed to be recoverable. We will ultimately recover them in a separate action, but the cure provision remains an option because the court under the RPAPL can allow the shareholder to cure at any given moment. And even a year, 2 years down the line, even after you win a trial and there's a warrant of eviction issued, they can still cure, which might be the right option, but not always.
So what's your advice then to boards as they evaluate these situations?
So I take a common sense approach to them. Often when I speak with my boards, I like to say I speak English better than I speak lawyer. And I like to take a common sense approach. Sit down with me and tell me, is this someone who you do not want living in your building any longer? Period. If that is the case, then the objectionable conduct route is the right move because it is an extreme approach. You're basically saying you are objectionable. We no longer want you here as our neighbor under any circumstances, period. If that's truly where you are, then that's the right approach. If what you really want is for the conduct to be corrected, then the simple holdover nuisance proceeding is the right approach. Breach of proprietary lease, I shouldn't even call it a nuisance proceeding. But that's a conversation to be had. And that's a conversation the board should have with each other because a board is made up of separate individuals who all have to have these conversations together and come to a consensus on what the right move is. Let's not forget, to go the objectionable conduct route, you typically need a 2/3 board vote. So you really do. I really encourage my boards to make these decisions to where they are 100% on the same page. And involve your attorney in those conversations, involve your managing agent in those conversations, but be on the same page. And I know that that's difficult when it comes to boards sometimes, but I have found in this one instance, it's really never difficult. I have never had an objectionable conduct case in any of my buildings where the board was not 100% on the same page because it really is that bad. And I can give more examples if you'd like, but
yeah, that I think always is helpful for boards, for our listeners to just sort of help illustrate the point. Just on the cat odor case, I mean, clearly in some situations there may be sort of mental health issues. At what point is a board perhaps getting a family member involved or reaching out or trying to sort of mediate?
So I think I highly encourage in all of those types of situations. And that involves collier, hoarding, odors, physical conditions in the apartment. if you have access to family members, I do encourage management to reach out and have conversations. Sometimes that doesn't go well and the shareholder gets angry because you called their brother, their sister, or their daughter, their mother, or their father. The other option is Adult Protective Services. And I'd like to say that that's an easy option, but it really isn't. Adult Protective Services is about voluntary cooperation. So I do encourage the management companies to do the outreach to Adult Protective Services if they believe there are some mental health issues involved. Adult Protective Services will ask for contact information. They will do outreach to the resident because it's not always a shareholder who is in occupancy. And if the shareholder, the resident cooperates, they will engage. They will offer cleanup. They will offer regular cleaning services. There are social services available for individuals who are willing to take them. However, oftentimes they don't engage. They don't allow it. They say, I don't need help. I don't need it. I don't want it. And the court system is really where that becomes a little easier to gain. However, even through the court system, once you commence a holdover proceeding for conditions like that, they can't force it. So the court will do an Adult Protective Services referral. They will send Adult Protective Services out to try to engage with the resident. If the resident appears in court, they will tell the resident they need to cooperate with Adult Protective Services. Sometimes that helps. But where they're not appearing and they're not getting that communication or they don't want to be cooperative, they don't have to accept the help. And sometimes if Adult Protective Services has a reason to believe that there is a serious mental illness involved, it will move into Supreme Court in an Article 81 proceeding, which is much more lengthy and complicated. An Article 81 guardianship basically takes over your life, while Adult Protective Services and a more limited sort of guardianship in landlord-tenant court is really there just to offer assistance and support. I would encourage everyone to allow that assistance and support because you don't ever want to get to the point where someone's literally taking your life over and your decision-making power. So it's difficult, but I do encourage that outreach up front.
And are there any other cases then that illustrate some of the nuance of this topic?
So I have had a lot of objectionable conduct cases over the years, and the conduct itself has varied from I had a situation with an individual who suffered from alcoholism and was extremely angry at certain members of the board, would follow them through the hallway, screaming and cursing at them. He was relatively tall and physically larger than these individuals. And I had to teach my board members to keep their phones in their hands and start recording whenever they were approached. Oftentimes when he would see that they were recording, he would back off. I mean, it's also a safety measure. So knowing that he's being recorded, he would back off, but then we'd have a record of what was going on. I had an individual defecating in plants in the lobby. Clearly there was a mental illness involved. It took a lot of Adult Protective Services intervention to help in that situation. I've had individuals who are very abusive of their neighbors. More recently, we had one in Upper Manhattan, Midtown actually, where the shareholder believed that the resident below her was making a lot of noise. Everything was a lot of noise. She would pound on the floor, pound on the walls, pound on the doors. She would approach them in the elevators. I mean, we had video after video after video of her in the hallways, at the front door, cursing and screaming and lunging her dog at them in the streets. There wasn't much we could do about that because it was in the street and didn't occur in the building, but keeping that record and having residents trained to report immediately so we could go get the video, which only sits for so long before it's written over to back it up. It was exaggerated, extremely exaggerated, the situation. And the poor resident who lived below her had lived with it for many, many years. When it was just him complaining, it was difficult to overcome the hump. Before I was involved, a prior attorney tried to do this and they lost the case.
Okay. So perhaps to drill home this point then, how does incomplete early record keeping affect the board's ability to take legal action? Because you pointed out that records, it's very hard to remediate that situation later.
It doesn't completely disable your ability to take action. It just delays your ability to take timely action. And in situations where you're dealing with someone who's truly objectionable, you come to me and I tell you, we've got to wait a couple of months. I need you to really build a clear record. Just means that you and your residents have to live with this a couple more months. And that's not always palatable to the people who are suffering. So
Yeah.
I don't know that I'm going to say you're going to lose the case, because if it's truly objectionable, it is something that gets repeated constantly. It just means you have to live with it longer. So keeping those records and maintaining them helps to bring solutions. Because if the board is bothered by the conduct, all the residents are. And everyone's having to live with it. I've had situations where residents have withheld maintenance because of this conduct that was going on, that that wasn't being addressed timely by the board. Of course, by the time it gets to me, I'm now looking to see what we have, and is this make a very clear record that would be upheld under the business judgment rule ultimately as a valid decision by the board. Belts and suspenders is always my approach. I have an ego. I'm a lawyer. I don't like to lose, and I don't think clients like to lose. So I like for things to be packaged very nicely and very clean to make this road as simple as possible.
And you mentioned earlier that legal action can be, obviously used strategically to secure compliance rather than eviction. But then a board does have to be aware that in that situation, you will be paying the legal fees. Is that what you're indicating?
Yes. Oftentimes when we reach a settlement, in fact, we're reaching settlement right now with an objectionable conduct case in Brooklyn, where the shareholder's daughter was the problem. And really all the board wanted was for her to not be in the building any longer. She finally removed the daughter. She's promising to keep her out. So we're restoring her. We're allowing her to remain and dropping the case, call it. But that's on condition that the legal fees are paid in full by the shareholder. So you can back off at any moment. And at that point, you really do call the shots, because it is an objectionable conduct action. There is really no legal defense as long as that they follow the process properly. So you don't have to walk away from the fees. In a nuisance case, sometimes you might. And what I say to that is, that's the cost of doing business. You're running a corporation. You are there to provide a peaceful living environment for yourselves and your neighbors. And sometimes you have to spend a little bit of money to get there. I don't like ever walking away from fees. I don't like paying lawyers. So I think my boards should be able to recover them whenever they can. I'm pretty adamant about that. And I think most attorneys in our field are.
Wow. Such good information. Is there any sort of final takeaway that you can leave our listeners with?
I think the takeaway is keep your records, and keep your records, and keep your records, and keep your records, and keep your notes. And please ask your neighbors who are complaining oh so feverishly about the conduct that they're having to live with to do the same, because ultimately that's what it's going to take to be able to get you the results in a timely manner.
Emanuela, it's been great chatting with you. Thank you.
My pleasure. It was great chatting.
Emanuela Lupu, partner at Smith, Buss & Jacobs. Thank you for tuning in to Habitat's coverage on issues affecting co-op and condo boards.